Good evening, everyone, fellow board members, administration, members of the public. I am Zachary Epps, co-chair of the policy committee. We'll call it to order with a roll call, starting with members of the policy committee. Mrs. Julie Haywood.
Yeah, Julie Haywood present.
Jennifer Lohman present.
Then recognizing our members of the board. Sorry, Charles, you are a member. I'm sorry, Charles, you are a member of the board. Sorry, Mr. Charles Riddell Williams. Present. And then recognizing our board members, President Henry.
Present.
And Mrs. Leah Muller.
Present.
Nice. We will move forward to accept the minutes from our last meeting, which was actually August 29th, 2023.
Second, Charles Riddell.
Nice. All in favor?
Aye.
Aye.
That is unanimous. I for myself as well. Minutes are approved, and I'll hand it over to administration to start off with old business.
Yes, we're going to start with policy 827, conflict of interest. This policy is scheduled to go up for adoption at the November 14th legislative board meeting.
We did not have any changes since the committee looked at this one in August.
Opening up to comments from the board. Seeing none, any members of the public on policy 827, conflict of interest? Do we have anyone online? Do I need to be-
Yes.
Oh, we do. Okay.
We have two people.
All right. Seeing none, we will move. Oh, this will move forward for adoption at our next legislative board meeting. I'll hand it back over for what I believe 800.
Yes, the next policy is policy in AR 800 records management, which is also scheduled for adoption November 14th board meeting, and the AR to be posted.
Yes, and since the last meeting, I think Mr. Schultz asked at the last meeting that we make sure we convert the attachment to a PDF before posting it. So you will note that the document attached to AR 800 is now in a PDF form. I don't think there were any other changes to the AR since the last meeting. We did have some discussion about this one at the last meeting.
Opening up to comments from the board.
Yes, Mr. Diazio, in the policy itself, we reference records and data. And then in the definition section of the AR, we just have a definition of records. Do you need a definition of data or data? We want to holistically reference records and data collectively.
I think the intention was that the data is the data that's in the record, like the content of the records themselves.
Yeah, I think we had made that change to the policy,
Okay,
and we have to clarify how records and data will be retained and destroyed. Neither of which we just have
yep.
in parentheses record, but not data.
I wonder if in the AR, the term record and data could be synonymous.
Yeah, or collectively referred to.
Yeah, yeah, okay. Record slash data, or
Yeah, I think that's fine. I mean, as long as,
I think that's the way, I think.
yeah, I mean, I think that probably would cover it.
Yeah, records or data. So then throughout the policy, if and AR, if only one is mentioned, it's the same definition.
Okay,
Thank you for that.
You're
It's the same
welcome.
way.
Any other comments? Moving to members of the public on 800. As mentioned, that will move forward for consideration for adoption at our November 14th legislative meeting. We can move forward to 8:30.
Yes, 8:30 is the security of computerized personal information / breach notification policy. There's an AR associated with that policy. And as we discussed at the last meeting, there were changes to state law within the last year that have required school districts to have a policy. 8:30 and 8:30.1, which is the next item that we'll look at, sort of go together. Policy 8:30 talks more about the steps that the district must take in the event of a data breach. 8:30.1 talks more proactively about the way in which the district stores and secures records and data internally. And again, those two policies are meant to comply with the state law as it's been recently revised regarding notifications when there's a data breach. We have separate policy. These two policies are not written with FERPA in mind. We have a separate student records policy, which talks about our obligations under FERPA. We deal with FERPA much more than we deal with the Data Breach Notification Act, but it's still important to have the policies nonetheless. There were not significant changes to either 8:30 or 8:30.1 since the last meeting.
So we can open it up for comments on both of those.
You could,
correct. For 8:30 and 8:31. Any members of the board? Members of the public? Comments on 8:30 or 8:31 as described by Mr. Diazio?
I don't see any hands raised.
All right, thank you. That, as mentioned, as all of our old business has already had a first read, so we'll move forward for consideration for adoption. And we can move forward to the next policy, 907.
907,
what be the next?
so policy in AR 907, which is visitors to district schools during the school day. That is also up for adoption.
Correct. And we have, we've had a lot of discussion. We actually had discussion last school year, and then we brought this one back. This school year, we've incorporated language for how we will handle scenarios where someone may have a legitimate reason to be in a building, but may not have an ID. Mrs. Lohman brought that concern to the committee last school year. We've addressed that. So this is back before the committee for a second review. We've actually, the board may have seen in the board update that went out last week, the Student Services Office and Special Education Office are implementing some new forms when agency workers are coming in either to evaluate a student or to witness a student in their school setting. We actually wrote those forms consistent with the language of the anticipated adoption of this form. Special Education and Student Services wanted to roll those forms out. We took a look at the requirements of 907 as we anticipate the board will vote to amend it. And so there is consistency between those documents.
Opening up to comments from the board. Ms. Hager?
Yes, Mr. Diazio, I know that this is basically visitors to district buildings during the school day. And I'm assuming this also applies to board members, just holistically.
It would, correct. Yeah.
Mr. Bernal Williams?
Just a quick observation. I appreciate the effort around, finding the right language to appropriately describe what to do or how we should respond when somebody doesn't have an ID, right? That's, I think, a huge step for us, and appreciate folks for that. Just a question, or maybe looking at the the name of the person being District Safety and Security Coordinator. I know in most places we reference or designate just in case the individual isn't available. So I think that might be an opportunity for us to broaden the language a little bit, because we know that our District Safety and Security Coordinator probably takes some time off every now and again. Maybe be unavailable at some point in time. So
Yes, and Mr. Virgil Williams, is that in the policy or the AR?
that is in the AR, sorry.
In number 4?
That is correct.
Okay, I see it here. I'll make that change now.
Sure.
I think that's a good point.
I recall, can't recall if it was under this or the weapons policy, but we had a discussion about at times where, and I don't know if this is something that needs to raise to the level of policy, so that's where my question is. I recall we had some conversation around incidents at a school where someone arrived. I guess I don't know if it was a visit, but someone arrived, was on school, maybe this was under the weapons policy, but arrived to the school with a weapon, but happened to be a law enforcement officer down those lines. Is that a situation that we want to raise to the level of a policy? And would that be other weapons?
I think we had that discussion in the context of the weapons
The weapons,
policy.
okay.
Yeah, which is on tonight's agenda.
It is,
so-
yeah,
so
it
we-
is,
We will
yeah.
get there, yes.
All right, I'll pause.
Excuse me. Related to that question though, the weapons policy that, or the two, one is for students and one is for staff.
And then
And
904
904.
is for community.
Okay, thank you. That's the public attendance policy, not.
Which contains a requirement or a provision that says no weapons.
Okay, that's what I was trying to get.
And you'll see that that's a cross-referenced policy 904,
Okay.
which is the policy that establishes that rule of no weapons.
Any comments from the public?
There are no hands raised on the Zoom link.
Mike.
In the policy, there, I'm sorry, did we cover the part if a person comes in and goes through visitor management and they're flagged? Having a Bacon's Law history?
No one's brought that up to my knowledge. Would you like to mention?
Well, I know the policy that we've been working under, when Dr. Horsey was Director of Student Services, that if a person came to the school, goes through the Raptor system, and we have a hit, and if they're there for legit business, they would need to contact the Director of Student Services to be admitted into the school, to wait in the office, and then to be escorted, if they have to be escorted by either myself or the principal, to the location they need to go to.
Yeah, that is actually.
I think
in
there
the
is
pol-
something.
the
Yeah, that's in there.
I'm
Yeah.
trying to find it
It's
because
not now.
I know we have it. I know it's addressed.
Yeah, section
5B.
5B. Yeah.
Yeah,
Yeah.
that's it.
Yes, must be supervised by a district employee during the duration. Thank you, Mr. White.
No, thanks. All right, that will move forward. Yeah, no, I appreciate it. I mean, on both sides, because it's not disqualifying.
Correct.
There's legitimate educational interests, and we have procedures in place to ensure safety of students. So this will move forward for consideration for adoption, and we can move forward to our next policy 109.
Yes, so 109 is the school library materials policy. For those of you who might remember back to August, we were having some technical difficulties when we were having the discussion last month about this policy. So I tried to make the revisions that were reflected in my notes. The one comment and discussion that we had last month that is still not incorporated, and keep in mind, 109 has not gone for a first reading yet, so we can make any changes in tonight to 109 and still move it on to a first reading. There was some discussion about the American Library Association's statement and a discussion by the board about maybe wanting to enhance this statement. And we talked about a couple different ways to do that, either to leave the American Library Association's statement intact and to add a sentence afterwards that says, furthermore, it is also, the purview or the policy of the board that the library material selection process should do the following. And I think the board was considering building in some language around race. This policy addresses a lot of different protected classes, but race is not specifically addressed. Alternatively, I think we had a discussion about maybe putting an asterisk next to certain of the Roman numerals and actually changing the ALA statement. I think, as I went back and looked at this, I think the first course, the first strategy may work better because I think it's going to be hard to modify the ALA statement, but still refer to it as the ALA statement, right? Like that's the statement that they post on their website. I think if we want to incorporate into that into our policy, we should leave that intact, but create whatever additional language the board might feel is necessary to enhance the overall meaning of the policy. That's the one change that has not yet been incorporated. We did make some changes. I know we had a discussion about retaining some of the district sharing language because of the partnership with the library. So some of that language has stayed. And then we made some other changes in real time at the meeting last month. I think the district sharing language and potential modification of the ALA statement were the two things that were left unresolved. I think we've resolved the district sharing piece at this point in time, but if there's further discussion about the ALA statement, we could certainly do that at the meeting today.
What are comments, Ms. Hussein?
Yeah, I think that was something that I'd raised last time, and I'm perfectly fine with kind of adding a additional sentence to the ALA statement. I do think it'll be very difficult to modify the ALA statement, and I'm not opposed to the ALA statement. However, I think the point that I made was all of the protected categories under the law are not mentioned in ALA statement 7. So adding another statement that furthermore, the school district of Cheltenham believes that all people, regardless of race, ethnicity, all the protected categories. And then kind of keep the same language.
Okay.
Is what I'm proposing.
Yeah, that is.
We can definitely make that change.
Jeff,
I think that's all. Thank you.
Mr. Burdell, did your hand?
Wheels are turning. I'm good. I think I'm okay for right now. I align with what Julie's recommending, just broadly. I think I'll leave it at that.
Ms. Loman, did I? I'm sorry.
No, I agree with that approach as well.
Opening up to members of the public.
And there are no hands raised.
Appreciate the comments. Oh, Ms.
No, I mean, this is more just sharing. So the library system just adopted a really robust collection policy that I'll share just with the board. It's just really very comprehensive.
Great.
I guess maybe we could talk about this, maybe not here, but I do just, does the, more, maybe I think this is the appropriate form just right now. Does the Cheltenham Library System have a similar Bill of Rights that is?
They do cross-reference the ALA.
They do cross-reference ALA there. Okay,
Yeah.
all right. Thank you.
Mhm.
And they're pretty active on social media and in the advertising that they do, that they promote themselves as a public library system that I think is aligned with the ALA statement.
Oh, sorry.
Oh, that was, that was definitely.
No, that was not, sorry.
All right, this will move for first read
Correct.
at our November 14th meeting. And we'll move forward to policy 218.2.
So this is the student, what policy on weapons that's in the student section. A couple changes that we discussed at the last meeting. The committee recommended a change in title from weapons and dangerous items to weapons. We added a definition of possession. And there was a request to specifically reference the attachments to policy 218, so we did that here. And we added some cross references to the relevant policies. So this is a policy that prohibits students from having weapons on school property, and consistent with the school code, contains the language that a violation of that policy is an offense that carries with it a 1-year expulsion, with the ability, obviously, of the superintendent to recommend a lesser term of expulsion if there are circumstances that warrant that. We'll look in a moment at the policies in the employees section and the community section of the manual that also deal with weapons.
So opening up for comments from the board. The language around possession, is that a straight grab from another legal mind or resource? Before I ask my question.
I believe that I want to say that came from the student searches policy, because I think there is a similar definition in the student searches policy. I don't believe that possession is a legally defined term. I think that's a term that we have developed over time. What we want to make clear is that it doesn't just apply at school, it also applies to any school sponsored or supervised activity.
Mm-hmm. What I was looking at is that clause in a vehicle used by the student. I guess in connection with the next clause, it sort of makes under a student's control is a bit more clear. And so that in a vehicle used by the student, does that mean like they're driving in that day? Does that mean they were a passenger in the car? It's just, to what extent would we need to be more clear around that?
I think what that's meant to say is in the student's vehicle, but obviously ownership of the vehicle very likely would not be with the student, right? It might be the student's, might be technically owned by a parent or guardian.
Yeah, that's why I didn't say ownership. But it's literally
Right.
the same thing, but that next clause under the student's control. So like using a vehicle, there's a lot of different ways to use a vehicle.
Yep.
If it's under your control, that is really like, okay, you have a level of responsibility that, you know, ties you to this weapon. That's beyond just a general use of a vehicle.
We probably could get rid of the statement that says in a vehicle used by the student, and instead it would say in the student's locker under the student's control while they are on school property, you know, including in their vehicle, or including, I think we could, because if the student is driving to school or they're responsible for the vehicle during the school day, that would be under their control at that time, right? I mean, I think that's what we, maybe there's a way to combine those two. Because I do agree, I think, as I read that, in a vehicle used by the student could be.
Maybe a vehicle operated by the student? Because use could be a passenger or a driver.
The only thing with operated though, to me, that means that the student is operating the vehicle at that time, but the
could be-
weapon could be in a car that the student has parked in the parking lot.
Right.
So
And we-
they
and
may
we-
not be operating it at that time, but
No, totally. But it's still under the control of the
But
student
it's
because they
under the
have the
control, right.
keys, they have. yeah.
Right.
They know where it
Responsibility
is,
is having
yeah.
that vehicle
yeah.
that day.
They know where the bar is. So yeah, we don't have to solve it now, but something, I appreciate the language around under students' control, because that's just very clear, and there's a clear line that can be drawn from there, that use. Oh, okay, I'm seeing hands and people are, there's a
Some of
few
us
twitches
just,
tonight, there's twitches
You
tonight.
know, our hands.
Okay, cool. We can move forward. Any comments from the public?
There are no hands raised.
What do we think about changing the word used to operated? To Julie's point, that addresses the situation if the student is actually operating the vehicle. But to Pam's point, if they weren't operating the vehicle at the time of the infraction, it would still be covered by the under the student's control. So it kind of covers both. It just clarifies the word
It
used.
does.
That's true.
Does the committee like that
I'll
proposed
start with
change?
President Henry, you mentioned some comments.
So what I'm also thinking though is, so you could have two students, one student that may have a weapon.
Yep,
Maybe that vehicle is not under their control, but they are the ones they're the student that is
To put it there.
responsible for the weapon in the car.
That would be the under student's control. That would cover that.
Well, is it under their control even, because if it's not their vehicle, like a
No,
vehicle?
no, not, they could still be in the vehicle, but the
Okay,
weapon could be under their control. So I think Ed was going to be suggesting,
okay,
kind of addressing both concepts.
okay, I got it.
So if they were operating the vehicle, and then they also.
In the vehicle, got it.
and then
That
the
makes
weapon was
sense.
under
That makes sense.
Just, yeah, just to verbally support, I support that as well. As one board member.
okay.
And this is a first
This will be moving to a first
read,
read,
yeah.
correct?
Not that wouldn't have amounted to a
Correct.
substantive change.
Correct.
All right, so that will move forward for first read at our November meeting, 218.2. And that's concludes our old business. We can, I'll hand it back over to administration and take us through our new business.
Yes, we have 4 policies under new business. The first is 904, that's public attendance in school facilities. And this was added because we were discussing the issue with the weapons on school property.
And there's not many revisions proposed to 904. The policy stated that service animals are permitted in accordance with law. The statement that follows that no other animals are permitted was missing. So that was just an additional sentence that we added. We clarified, consistent with current practice, that any like fee schedules, like if there's a cost to the, if there's a $5 cost to tickets for the football game, that's a fee schedule that's developed internally and approved administratively. That is not the type of fee schedule that gets presented to the board. So we clarified that approval process. There were no other real changes to 904, but there is language in 904 that talks about weapons being prohibited on school premises. So that policy would apply to any community members that come to our buildings.
Opening up for comments from the board.
Do we have a policy somewhere else that incorporates the Gun Free Schools Act for people, for the community? I mean,
It would just. In our manual, 904 is the community policy
Okay.
where the weapons prohibition
okay.
would be.
Yeah, I just. I mean,
Obviously, the law exists.
Right, yeah,
Independently
yeah.
of policy.
see, right, yeah, okay, that was just one question, I couldn't remember. The other question doesn't have to do with weapons, it has to do with, and I'm so like out of the loop on this, I'm not gonna use the right terminology, but vaping and e-cigarettes, I know that it seems like it covers some of that, but they're not all nicotine delivery products, you know what I mean?
But we have similar policy though, I think it is.
Okay,
We do, and this policy here, we define nicotine delivery product
oh,
as,
there's vaping,
or it's a product that's intended for ingesting nicotine or another substance.
okay,
Because sometimes it's THC,
Right.
sometimes it's all different types of
Marijuana.
things that we find that get found in these devices.
Ms. Mole, Mrs. Mole.
Is there a reason why we do not, or maybe there is, why we define, we have under definitions, we have tobacco, nicotine delivery product, but we don't have a weapons definition? Whereas in the student policy, there is a weapons definition.
We could add one. I don't know that there's a reason why.
So
we-
just curiosity, and I think when you first, if you just glance at the policy, it seems to be about smoking on school property,
Right.
not anything else. So clearly that's not it. My other, so that's just a question whether we should have more definitions about the things that are prohibited. And then maybe minor, but is there a reason or why we call out athletics specifically and just other events? I mean, it's meant to be any event that's at school. I don't know. Is that what most, I don't think most of our events are athletic events. I don't know, maybe they are. Just, that's more semantics. It doesn't actually substantially change anything, but more curiosity.
So this would be generally where this policy becomes applicable is district events that are open to the public. So it frequently comes up
I see.
in athletics because it's
Versus,
versus the students that are participating in the sophomore dance.
right, or even a
that are-
concert or a
that are not
play,
open to the
maybe.
public, right?
Okay,
Now, some of those things,
No, those
sometimes,
things are
sometimes,
open to
sometimes
the
the play and the
yeah.
concerts are
Yeah.
open, so
Yeah.
it could be
Just-
those things.
yeah.
Um,
I wouldn't say that's something I feel strongly about. I was more just curious, again, trying to understand. That makes
So I have a question under authority, because it says the board has the authority to prohibit the attendance of any person, which the board typically would not be the entity, policy would, but the board wouldn't actually be prohibiting a person from attending an event.
And actually, there should be a cross-reference to 907 because at that point, when someone comes onto our property, they're a visitor.
Right.
And the visitor's policy delegates to the superintendent or designate the authority to remove someone.
Right, so that's,
So if you were to read the school code would say the board does have the authority.
okay,
The board delegates that
Gotcha.
authority to
Okay.
the superintendent. Let me, if the committee's okay, I'd like to add a cross-reference to 907.
Mr. Diaz, could we also give a definition for disruption? Under authority, so constitutes a disruption. I think that needs to be defined. What constitutes a disruption?
We can look to do that. Usually it's within the purview of the superintendent to determine whether the school environment is being negatively impacted. If we go to, let me take a look at 907, because this will address, I think, both your question, Dr. Scriven, but also Ms. Henry's comment.
And even if that's the case, I just want it to be explicit.
Mhm.
So perhaps, so in 907, we say superintendent or designee has the authority to prohibit the entry or seek the removal of anyone who does not follow the guidelines in the policy, the directives of the superintendent, building principal, or any law. So I think it would follow that disruptive behavior exists when you are not following the rules, when you are not complying with the law, when you are not following directives from those who are carrying out the rules of the district. So,
No, that's good.
so we could try to merge them
Yeah.
better.
So under 900 community, copy of visitors to school districts during the day, it specifies under additional visitor guidelines. In the event a situation involving a visitor arises which presents a threat to the health, safety, or welfare of staff, students, other visitors, volunteers, and district property, the superintendent, building principal, or other designee is authorized to take appropriate action as deemed necessary. So that clause is in 900.
Any other comments from the board? Opening up to members of the public. So when taxes change, they can come to us, but the price of pizza or M&M's. All right.
Can I actually,
Yeah.
can I actually just another quick, we can get back to it, I'm on 904. And we referenced, I think you did, Zach, Mr. Epps, talking about an incident that had occurred at a school where this is the policy that had come up, correct?
It was probably 356.
That's 356.
Yeah.
Oh, then I'll wait.
356 is
No, that's
employees.
employees.
Yeah.
Oh, so then,
So I guess,
was it then 904?
I think because that's a visitor
Yeah, it probably would
or a
have
guest,
come up.
a public. I guess, so I think that I guess I'm curious if the incident in question falls under this policy, which is a parent or the guardian or anyone that is on school property that has a weapon, regardless of why they have that weapon, would fall under this policy, correct?
So the answer to that question is state law prohibits weapons on school property. But it also contains a provision that says that it's a defense to that violation, that you were possessing the weapon for another lawful purpose. We've had recent situations here where law enforcement officers who are parents, right? So you have a
Yes.
parent or guardian of a Cheltenham student who's in their uniform as a law enforcement officer of another municipality, and being in uniform, they have weapons on their belt, right? We've looked at the state law, and what we have said is there's not a whole lot we can do other than standing behind our policy, which says we'd ask you not to do that, because law enforcement very likely would not charge for that type of violation. There's actually recent case law interpreting that defense, and the facts of the case in that litigation, I actually thought were, it was a case where, I actually think I'll explain it. So a parent was asked to come to school because their child had been disciplined for a weapons offense. Okay, parent needed to come to school for some sort of conference. The parent or guardian came to school with their own pocket knife and took it out during the meeting and said, "This is my pocket knife. I use this to open my cans of tuna fish at work during the day. What are you gonna do, have me arrested?" And the school said, "You're not allowed to have that knife in this meeting." And law enforcement was called. That individual was charged with a weapons violation, and it went all the way through the court system, and the courts said, no, that weapon at that moment was being possessed for another lawful purpose. sort of a surprising outcome in the moment.
lawful.
But that is the current status of the case law on that other lawful purpose defense. And so law enforcement would say, given that that's the case law that we are being dealt with, we can't charge a fellow law enforcement officer. Or so there could be scenarios where they would say, no, that's not another lawful purpose in this scenario. But that case, in my mind, those facts were not helpful to entities like a school board in trying to craft weapons policy.
No, thank you, that is helpful.
And we've, Dr. Scriven and I have had conversations about how do we address these situations? How do we diffuse those situations as opposed to making them, more chaotic than they need to be.
That will also move forward for first read at our November meeting. We'll move forward to the next policy, 356.
Yes, 356 is the weapons policy in the employees section of the manual. And I don't think there were no changes that are actually being proposed to this. Those who have been around on the committee for several years will remember we had a lengthy discussion about this one back in 2021 when we were talking about how do you handle a situation where a staff member wants to have a weapon as part of like a historical, I think we talked about historical reenactments, right? We had a lengthy discussion about that, but no changes proposed currently, but we wanted to bring this one forward because we were looking at all of the weapons policies together. And I think we put language in here that in no circumstances is last sentence under the first paragraph in guidelines, under no circumstances will a loaded firearm be permitted on district property for any reason. So that was the result of the conversation we had about what could a legitimate lawful purpose for a staff member look like, and the board wanted to set the floor of never a loaded firearm.
What do you have for comments from the board? Comments from the public?
No hands raised.
This also moves forward for a first read at our November meeting. We can move forward to the next piece of business, 918.
So 918 is the
Can I-
title.
can I just- I'm sorry, just go back to 356. Should we cross-reference the other student weapons policy? I mean, I know this is for staff,
Right.
or 907 maybe. I mean, I guess a staff, it could be considered a visitor at a school-sponsored event, potentially.
Yeah, I think, and there could be where a staff member that's also a parent, it could be attended. I think, I don't know that we need to cross-reference 218.2 because our employee would never be our student.
Right.
But I think it would probably make sense to cross-reference 904. Yeah. At the right title, public attendance at school events.
School facilities, in school facilities.
In school facilities, okay.
Any other comments on 356? Hand it back over to admin for 918.
Yes, 918 is next, Title I, Parent Family Member Engagement. This is the Title I policy. Title I is a federal program that provides funding for students that are identified as at risk based on primarily based on free and reduced lunch criteria. This policy, as part of the Title I requirements, school districts have to make pretty concerted and regular efforts to include parents and family members in discussions about programs at school. So this policy memorializes those steps. This policy looks a little bit different than our traditional policies, where usually the policies are short with high-level statements and the more specifics are in the AR. That's by design with this policy, because when the state auditors come out, they want everything in policy. There's a couple other policies that look like that as well, but this is one of them that they want. They're always looking for all of the language to be in policy as opposed to in AR. Dr. Smith's office specifically asked that we look at this one this year because I believe we are coming up on our cycle of review where we know this policy is going to be looked at. The policy gets looked at administratively on an annual basis, but it's been 4 years since we brought it forward to the board. So even though there's no revisions being proposed, we wanted to get an updated revised date because that will make, it's easier for the auditors to see a more recent date to see that it's actually been publicly reviewed within the last year.
Comments from the board?
Just a clarification, accessibility, when we use the term migrants, are we also including refugees? That would be a legally different category, I would think. So we basically are saying that we'll provide communications about the Title I program to parents and family members who are migrants, who have limited English proficiency and disability, limited literacy or racial and ethnic minority backgrounds, in a language they can understand. So my question was, whether that should include refugees as well.
Yep. I'm going to confirm that with whoever in Dr. Smith's office. The answer is probably yes, we can probably add it.
Okay.
Accessibility, refugees. I don't think there will be any problem adding that.
Ms. Lynn?
Yeah, thank you for that explanation, Mr. Biagio, about why this is such a comprehensive policy. It's very detailed, and I just am. I know we just sort of had a presentation from Dr. Smith about our Title I work that we're doing in our Title I buildings. I just, as one parent, not speaking as a board member now, but as a parent, at a time when Glenside, I think, was a Title I building at one point, I don't really recall any of these things actually happening.
I get that comment from board members. That's not
Okay.
unique to children.
Okay.
Usually where this plays out is usually once or twice a year, there are parent engagement nights where a lot of this plays out. And what we could do, I'll propose this to Dr. Scriven as an option. I'm wondering if there's questions about what we are doing with respect to that, we maybe could ask Dr. Smith to write up something for the next board update.
Okay, that would be helpful.
That might be helpful about how operationally this is carried out.
Yeah, that would be helpful, thank you. And it's been a while since I looked at Title I, and it's probably, I know it's changed, but is there somewhere in here that talks about how Title I schools have to have school advisory councils? Or is that only district-wide Title I recipients or something like that?
So there are requirements in here to have, I think, are they called compacts?
Yes, school parent and family compact.
Yep.
Yeah,
Is that the language?
it's not quite
What did you call them, advisory?
school advisory councils. And it could just be where you have districts like Philadelphia where the entire district is
That's
Title
here.
One.
Establish and support active and engaged Title I parent and family advisory council.
Yes, okay, yeah, that's it, yeah.
It's there. This is in the,
Guidelines.
yeah.
Oh, it is there, okay, thank you.
Mhm.
So maybe- that's good to know.
I think it'll be helpful for the board to just get some narrative for what are the primary ways that the district does do the required outreach to parents and family members. And the good thing is this is only going for a first read. So in between now and the next time we're back, you'll have the benefit of receiving all of that information, and it might inform additional feedback.
And Dr. Smith definitely did cover some of this.
Yeah.
She definitely did. I think it was just, when you read the whole policy,
Yep.
you're like, oh my goodness.
It's an incredibly detailed policy. It's actually a template policy
I
that
have
the
one of those,
Commonwealth
yeah,
gives you.
yeah.
And it's, believe it or not, like in everywhere I travel, board members always say, are we actually doing all of this? And usually they are. So we'll just get some additional information to pass along.
Comments to members of the public?
No hands up.
Right, as mentioned, 918 will move forward for first read. We'll move to our last piece of new business for today, 247.
Yes, and this is also one that Dr. Smith and Ms. Keene's offices flagged as needing attention this school year, because this is a policy that gets submitted every 3 years. And so we are coming up on our 3-year due date for the bullying policy. So that's a requirement of school code that the bullying policy get reviewed every 3 years, and it gets submitted to the Safe Schools office. So we updated the email address here for the Assistant Title IX Coordinator. That's Mr. Flory, not SUNY Blackwell. And I think that was the only change. Yep.
We have two comments from the board. Mrs. Haywood.
And I'm sure, I think, no, we see it. Pull my question back.
Okay. Well, what is it? I mean,
Well, it was, I just wanted to make sure that cyberbullying was
okay.
included.
Didn't have a chance prior to the meeting, but I will, back to our conversation around, and this is not to rehash that conversation, but just to heard a piece of it. We were talking about seclusion, not to go back there, but we were talking about language. And we ended up finding a lot of resources that was a bit more expansive than what we were currently using. And so it came to mind, bullying and harassment. Is there like a golden template that may be more expansive than what is traditional when approaching bullying from a policy perspective? There might be some, I don't know, best practice language that goes above and beyond. I mean, it's pretty clear. I'm not saying we need to make changes to this because it's pretty clear, straightforward. It was just wondering if other things might be out there, similar to our previous conversation.
I think what we see more and more of is complaints that come in under the bullying policy that actually, under the expansive scope of what Title IX has become in recent years, with the expansion into the realm of gender identity. We are seeing more complaints that ultimately get investigated under Title IX, which is a more rigorous process than we did years ago. The Title IX process here is we've done, so obviously there's a coordinator and an assistant coordinator. We've done training in the past, and we have another training on the books for all new administrators. I think Dr. Scriven will even be participating in the next one. It's on the schedule. It's either November or December. We're seeing more and more activity in Title IX. That's not to say that we're not still seeing and investigating complaints of bullying, but it seems that many complaints of bullying tend to have a Title IX component to it more and more frequently. And the good news is there's a rigorous set of guidelines and a defined practice and set of procedures already in place to handle those complaints.
Thanks. Any other comments from the board? Or members of the public? Oh, coming back.
Yeah, just one thought, and this is more also about the operationalization of all of this, is it also brings, again, to mind sort of how this is conveyed to the students and, you know, how do they know kind of what to do, or their families know what to do, or something like that, and you know, inclusion in the handbooks of each building and all of that kind of thing. I know that's sort of beyond the scope of all of this, but this one feels particularly like
So many times the complaints come in. We actually just had one within the last couple of months where the students who reported conduct had no idea that there was a Title IX process, but you train the administrators to know when a student's saying these things, you advise them of the process. And so, you know, the communication ultimately comes out of Ms. Jackson's office. But we just had a student complaint within the last 3 months that we just wrapped up and investigated under the Title IX. It didn't come in as a Title IX complaint, but the building principal at the middle school was aware to know that the things that are being reported, yes, they might be bullying, but they could also have a Title IX component, and we have an affirmative obligation to advise of our process. So, which is, it's actually one of the lessons learned from one of the recent complaints was we realized that it's been like 2 or 3 years since we've done district training on Title IX, and our administrators have turned over in many cases. So working with Dr. Scriven and Dr. Smith, we identified a date in November or December. We're doing another training.
That's and thank you for that explanation. I think and I would assume that, like, safe to say is another way that complaints of bullying would come in pretty frequently. So,
Yes, it is.
yeah, okay.
Right, I assume you checked, because we were in the middle of the public, you already checked for the questions.
Yeah, there's no hands.
Just checking. All right, so that'll move forward for first read as well at our November meeting. That concludes our new business for tonight. I'll await a motion to adjourn.
Oh, we should just note for the record that this is Mrs. Haywood's last policy committee meeting.
Wow.
Defer to the chair to recognize.
Julie has to attend all the
I've been with this group in policy for several years, and those who have been around, we have made so much progress in this manual in recent years, and Mrs. Haywood has been our constant on this committee, usually as the chair. So she can take credit for a lot of our work over the last many years. So we hope we'll continue to see you around.
We might have withdrawal, but not on Tuesday. But I also want to thank you, Mr. Diaz and Jackson as well, and administration, because we have gone through a lot of policies but it takes a team effort, so thank you.
Nice, we'll have to run down those stats. I know I did at the legislative
I'll put
board
it- I'll
meeting,
put it
but.
together.
We're big on
For the
the
policy report. All right, I'll await a motion.
Second.
For a second.
I just have one, and this is a procedural question. I mean, I know that we're not meeting that often, well, you guys are meeting that often. And so having 2 consecutive meetings in order to be able to take something for board approval, I guess you guys will determine if there's any time you need to maybe have an ad hoc meeting
Correct.
that would require approval of a policy sooner than like 3 months, right?
Yeah. Yeah. We can also look, there are certain circumstances where the board can likely waive the second reading. I think we have policy language around that, but we will look into that because we're just starting to deal with that now. Because this school year is the first year we aren't really meeting every month. So I think it's a good point to keep in mind.
Thanks, I think technically we adjourned, so.